You're listening to Sound Money from Casey Research.
Hello and welcome to the Sound Money Show from Casey Research with me, your host, Andy Duncan. It's my pleasure today to be speaking with Doug Hornig, Senior Editor at Casey Research. Today we'll be speaking about your security in Securities, the dangers of rehypothecation, and how the Bankruptcy, Abuse Prevention and Consumer Protection Act of 2005 may have abused your consumer protection. Hello, Doug.
Hi there.
Now, along with your co-author David Webb, you recently wrote a special report for Casey Research called Insecurities, Why Your Stocks and Bonds Are No Longer Your Property. This sounds very worrying. Can you tell us all about it?
Well, yes. First of all, just let me say that you can get a copy of the report. It's free, available at caseyresearch.com/insecurities, or if you go to caseyresearch.com, you can just click on the Reports and Books tab and get it. The problem is, let's say you're a Joe average investor, and you have a simple brokerage account, and you think that in your brokerage account you have some stock that you bought, you paid for it, it's yours, no problem. Problem is that it isn't. And what would happen to you if all of a sudden all those securities in your account were frozen for a year, 2 years, 3 years, 4 years, indefinitely, or just evaporated entirely? I think you'd be pretty angry. And the fact that nobody in this country is angry about what's going on is that they don't know about it yet. Even really professionals don't understand what's going on. It's pretty complicated, but I can simplify it, I think, and I'll try to do that over the next few minutes.
So I think, didn't it all start with the North American Clearing Company and its relationship with U.S. Bank?
Well, that was an early case of what's going on. The problem is that secured creditors, and we need to understand the difference between an asset holder and a secured creditor. If you're an asset holder, that means that you have an account in which your assets, stocks, bonds, or whatever, are held. Those assets can be used by your broker in certain circumstances to finance as collateral to finance deals of their own or deals that involve other people's accounts. The secured creditor, which is almost always going to be a large bank, holds something like a home mortgage owner. But in the case of a home mortgage, you know that the secured creditor, that you have title to the house, but the secured creditor has a higher claim on the house if you can't pay your interest and your monthly payments. They can take it back. So everybody understands that. But in the case of a securities account, it's almost as if you bought a car from a car dealer and paid for it in full. Can that car dealer then post your Volvo as collateral for if he goes bankrupt when you already own it? Of course not. People would be so outraged. One instance of that would generate a huge amount of publicity. In the case of North American Clearing, the broker used client assets as collateral in a deal that they made, and when they went bankrupt, those assets were frozen for quite a period of time, and those people who thought they owned the stock didn't really, because the broker had already used it as collateral, and there was a secured creditor ahead of them in line. When an insolvency happens now, there's a line, and the people at the bottom are the people who think they own those assets. And that's what happened in North American Clearing. Now, the last we knew, most of those people at the retail level, the retail brokerage level in the North American Clearing case, had gotten their assets back, but that was after it had gone through receivership and then the trusteeship of the SIPC, which is a long, involved process, and all the time those people were waiting to get their stuff back. So you may get it back, you will probably get it back, but it'll take a long time, and in the end, it's possible that you won't. It depends on the extent of the bankruptcy. So far, we haven't had a sufficiently large number of bankruptcies to really bring the system down and see if everybody's going to get what they want back.
Now, there was a principle of Roman law, which came down to English law, which came down to common law. That's nemo dat quod no habet, which is one cannot give what one does not have, i.e., you can't receive stolen goods. And the actual word security itself comes from another Latin phrase, securus, which means free from care. It seems the financial industry has destroyed the meaning of the word security because it becomes the secured kind of loan holder and it takes your stuff in a safe harbor kind of way in bankruptcies of brokerages. How did the banking industry manage to achieve this and break this principle of Roman law, which has come down to us from 2,000 years ago?
Well, you're absolutely correct. That principle of you can't have what you can't own what you don't have. You can't own what if you receive it illegally. That is, in fact, out the window. We have to go all the way back to 1970. At that time, people could see that the electronic revolution was coming. Computers were going to get more powerful, and they had to try to deal with how that would affect the financial industry. So the first thing that happened is the regulators put forth a principle called dematerialization. Prior to 1970, companies, when they issued stock, had issued shares, paper shares, and they were written in your name. They were things you could get them in the mail, you could put them in your safe deposit box, whatever. After 1970, companies were approved to issue uncertificated shares. So these shares still existed, they were still in your name and still on the company books, but they no longer had paper backing. Okay? That's the beginning of the end. Even though it seems like a long time ago, it was a long time ago. In 1972, the SEC decided that we had better have something to cover what happens during an insolvency. So they enacted the Customer Protection Rule. By the Customer Protection Rule, which was also modified in 1974. But basically, what it did was, it said a broker who has accounts with customers in which they hold assets of various kinds, had to be able, in an insolvency, to immediately return those assets to the customer so that he or she could move it to a different broker or sell it or whatever they wanted to do with it. If they couldn't do that, they were supposed to have a cash reserve that would cover any possible liabilities that they had to their customers. So that would seem to be a very ironclad thing. And yet, as we'll see, it wasn't, because various laws and rules, codes that were passed since then have kind of supplanted it. The Customer Protection Rule is still in place. It's still the law. It's still part of the SEC code, but it's kind of been swept away.
And then we roll forward then through a set of other steps through to 2005, where we had the Act mentioned at the start of the program. And since then, we've had Lehman Brothers and we've had MF Global. Now, in your report, it seems to appear that John Corzine of MF Global, he may not have actually done anything illegal. He might have just behaved inadequately. Do you think that this standard kind of behavior of not being illegal is going to just become the norm in future similar cases of brokerage bankruptcy?
It depends on whether they punish them. And John Corzine is not going to jail, believe me. But there is a civil case pending against him. What he did was illegal, or if not him personally, what his company did was illegal. They used client assets that were supposed to be segregated from the company business. This is an important distinction to make. All brokers have a customer branch and then their own branch that they use for their own trading, and of course it may be even a little more complicated than that, but those two basic, there's supposed to be a wall between those two things. And brokers are not supposed to use customer assets in their own proprietary trading.
Now, as I understand it, if a brokerage wrongly uses your securities for collateral with a bank to get a bank loan, and then everything goes horribly wrong, as long as the bank doing the loan didn't know that it was customer securities, they keep the collateral. Is that right?
That's right. Now, basically, the law says that except in the case of provable outright fraud, not only on the part of the broker who sold who used your your assets as collateral, but also on the receiver of those assets, which is called hypothecation. As long both parties have to have knowingly engaged in fraud. Now try to prove that in court. Nobody's been able to do that in a long time.
And then this leads on to rehypothecation and rehypothecation and rehypothecation, the same collateral being used again and again and again and again to back hundreds of trillions of derivatives contracts. Why do you think the financial authorities, who are supposed to be looking after the ordinary person here, why do you think they allowed this spectacular house of cards to be built upon $1.2 quadrillion worth of rehypothecation?
Well, it's pretty much the same thing as happened with the mortgage-backed securities that caused the financial meltdown in 2008. The thing got out of hand, and now it's the case that probably if they started to enforce, regulations, or they started to favor the small asset holder over the big banks, then the big banks would fail, and the big banks are too big to fail, as we know. And they're very desperately afraid that they, being the government, they're very desperately afraid that there will be some kind of domino effect, and if one big bank goes, then another big bank goes, because they're all interconnected now and very, very deeply, and also with tremendous amounts of money at stake. The amount of the derivatives, the worldwide derivatives market now is estimated at, this is the low figure, $600 trillion. And I've seen people estimating it at twice that. So now we're using the Q word, quadrillion.
Quadrillion, it's a big number.
It is, and all this stuff is supposedly collateralized. Well, there isn't that much collateral in the world, so you know that it's a very, very shaky structure overall. But the courts had made it very, very clear that that the banks are going to have the right to do pretty much whatever they want to, and that in the case of someone bringing suit, in the case of an insolvency, someone at a lower level bringing suit against someone at a higher level in the food chain, the people at the higher level are going to be they're going to get screwed, and the rulings make this very, very clear. And in the case of Lehman Brothers, which was a landmark case, because Lehman Brothers, in their last desperate moments, gave away, or I shouldn't say gave away, but it sort of gave away. They collateralized all kinds of client assets in an attempt to keep themselves liquid and keep themselves from going under. So when the people who lost their assets brought suit against J.P. Morgan, which received the assets from Lehman, and it's inconceivable that J.P. Morgan didn't know that this was a fraudulent conveyance, but they claim they didn't, and nobody's going to try to take them to court to prove that they did. But in that case, the court ruled in favor of J.P. Morgan as the secured creditor, and that they were entitled to get, to keep whatever assets they had taken as collateral over the individual asset holders. Now, I need to point out that J.P. Morgan did eventually return a very large amount of that collateral. I think something like 1.8 billion or something like that. But the judgment, and here I'll read you. This is from the court's judgment itself. It says it is appropriate for the provisions protecting the secured credit holders to be enforced and applied literally in the interest of market stability. See what they're saying there? And they're saying, in other words, this is the precise setting in time of significant transactions between sophisticated financial players at a time of financial distress. This is exactly what the rules were meant to cover. So you see what they're saying there? They're saying, sorry, if you're not the secured creditor, we can't take the chance, because these are significant transactions between sophisticated financial players, and they may bring down the system if we allow it to happen. And there you have it in a nutshell.
So they're building a bigger and bigger and bigger house of cards. So when it does eventually come down, it's going to be spectacular. I suppose this is what happens when you throw away 2,000-year-old legal principles. Now, if people have heard this news for the first time, that when you buy a security, you're actually buying an insecurity, How can our listeners best protect themselves from these dangers of rehypothecation?
Well, it's not just the rehypothecation danger. It's the fact that in 1994, the Uniform Commercial Code created something called an entitlement. So when you think you buy a share of stock, you buy 100 shares of IBM. You don't have 100 shares of IBM stock. You have an entitlement to 100 shares of IBM, and the entitlements are all swimming in a big pool at the Depository Trust Corporation. And the Uniform Commercial Code says specifically a transaction is not the transfer of the same entitlement. So if you buy or sell 100 shares of IBM, you're not buying somebody else's 100 shares of IBM, and somebody else isn't losing those 100 shares. They all swim in the same pool. So it's not just the danger from hypothecation, it's the danger that if there is a really, really problematic bankruptcy, that no one will be able to tell who owns what, because the only place where your ownership is registered is with your broker. And your broker may be one that's going bankrupt, or his clearing participant that he uses to get to the DTC, they can go bankrupt. And either of those two people can go bankrupt, and that can affect you. So it's much like the case of some of these mortgage-backed securities where they get to court and the court looks at it and says, we don't know who the hell owns this. It's crazy. It's absolute craziness. There's no chain of ownership here. So, it's very dangerous, even if your shares have not been hypothecated, if there's some very, very big financial disaster, the fact that there's no chain of ownership is also going to be a big, big problem.
So how can our listeners protect themselves then from this craziness?
Well, that's a very good question. The answer is you can't really, but what you can do is you can take a look at your brokerage agreement. Simple brokerage accounts are supposed to be safe from the use by the broker in business of their own. So those assets are supposed to be inviolate. Like I said, that may still be a problem because of the entitlement issue. But if you have a simple brokerage account, that's probably the best thing to have if you're not a sophisticated investor. However, a lot of people who aren't sophisticated investors, and I'm one of them, I have a margin account. All margin accounts, because I buy and sell options occasionally. And if you do that, then you have a margin account. If you do any short selling, you have a margin account. If you do any futures trading, you have a margin account. All margin accounts are subject to the use of the broker for hypothecation purposes, and it's going to be right in your agreement, with your brokerage agreement. Go and read it, see what you've got, and if you have there should be a clause in there saying what they can and cannot do with your assets. And if there's nothing in there that says that they can use your assets for their own purposes, you're going to be okay, sort of. But if you have a margin account, you have to know that that's what's happening. They are using your shares, and they have to. They have to, because in order to do short sales or options trading, they really need the liquidity to be able to use people's shares for their purposes. So that's one step you can do. See what kind of account you have. Make sure it's the kind of account you want to have. The other thing is you can spread your assets across a couple of different brokers if you want to. You could split your IRA away from your regular investment account, whatever. I would say be very careful what broker you choose if you're worried about these kinds of things. I mean, I have an account with Charles Schwab. They've never been in any trouble before, and I called them up, and they said that they don't engage in any kind of company trading on the company account. So supposedly my assets are safe, and you might want to pick a company that's old and has been around for a while, and probably if you're just Joe average investor, you want to stay away from the big investment banks like Goldman Sachs that you know are going to use your assets for their own trading. And a simple broker, there's plenty of them out there with good track records. Pick one of them rather than one of the ones that engages in risky behavior. Or in the case of MF Global's failure, of course, MF Global was a commodities trader. So if you're not into trading commodities, you don't need a commodities account. Other than that, write to your congressman, write to your senator, bring this to their attention. send them a link to our report, and have them look into it. And the amount of tweaking that would be necessary to fix this situation is not very large, but it is something that the banks will fight tooth and nail, and they have all the good lobbyists, and you don't. So it can't hurt, however, and maybe some crusading senator, I won't name any names, but you know who they are out there, who are already taking on Wall Street, will make this an issue in the presidential election in 2016. Maybe. We'll see.
I always think it's a shame that Ron Paul can't be cloned and put back into Congress again and again, maybe 300 or 400 times. As well as diversifying between brokerages, do you think people should be diversifying into property and physical precious metals and other things where the bank can't grab it?
Absolutely. Precious metals and land and real estate and collectibles and whatever you like, it should be something that you're interested in, not something that you buy just for that purpose, but definitely good to be diversified into something that you're interested in, that you believe in, and that you can hold in your hand, and that you have real clear title to.
I think for me, that's 1,000 bottles of Pinot Noir wine. Yeah. Now, if our listeners want to keep up with your work, where's the best place for them to go?
Yeah, kcresearch.com. We have everything is on there. You can sign up for our free daily article, which comes every business day. We have a free article that comes out. You can get on our mailing list for other stuff that comes along, and we have a very large number of very interesting reports on the site that are free and available to everybody. It'll educate you about all kinds of different aspects of financial investing.
Thank you very much for your time today, Doug Hornig.
Okay, thank you, Randy.
You can subscribe to The Sound Money Show on iTunes or sign up to our podcast at Casey Research, where we'd also welcome your feedback. I'd like to thank our Casey Research guest, Doug Hornig, for taking the time to join us today, and I'd like to thank you for listening to Sound Money Radio. If you enjoyed today's show, please let all your friends know to help us grow this podcast. Meanwhile, and until next time, goodbye.